I found another article. This one is also on originalism, which gives us a chance to expand on that idea. Now, one of the things we were in a previous video were talking about was the idea of originalism versus incorporation. Some originalists believe the incorporation doctrine of the 14th Amendment essentially allows for the incorporation of the Bill of Rights in terms of essentially imposing the Bill of Rights upon the states, whereas some originalists believe that that form of incorporation is not what was intended by the 14th Amendment. And details of that you can look in my other video on originalism. So, just for my own purposes, I'm not entirely sure what to make of originalism yet. Uh, I don't know the different schools of originalism. The one that doesn't incorporate the Bill of Rights seems detrimental to me, but I'm willing to hear counter arguments to that. So, uh, this particular doctor went in and tried to explain that the founders didn't believe in originalism, and I pick apart some of his arguments here. I provide you the title of the article as well as his name if you want to make sure that I'm not just parsing him out and isolating his comments. I mean, to a certain extent, he repeats himself, so it doesn't pay to read it through line by line. So it's available to you if you want to look to see what he's doing there. Okay, so his name is Erwin Chemerinsky, and he has a BA and a JD. A JD is kind of the equivalent of a doctorate for a lawyer. Okay, a little bit on his background to put him in context. And this is stuff I pulled from Wikipedia. Yeah, I know that's not the greatest source in the world, but I doubt somebody who's writing an article like this has to worry about being besmirched too much in Wikipedia. Um, he thinks that even if an individual's right to bear arms exists, he believes the District of Columbia was justified in restricting that right because it believed that the law would lessen violence. So, I mean, obviously, his beliefs are so far away from originalism, it's hard for him to be a good arguer for it. Um, in his opinion piece following the 2020 presidential election, he wrote that the Electoral College makes no sense in a way for a democracy to choose a president. He writes that it was intentionally designed to be anti democratic and came about as part of compromises concerning slavery that were at the core of the Constitution's drafting and ratification. Okay, that's absolute nonsense. And if he really believes that, uh, he basically, his grasp of the historical situation at the time is very minimal. It's possibly he's just postulating that to show his bona fides to his political tribal unit. But so at the time of the Constitutional Convention, only one state didn't have slaves, and that was Massachusetts. The large slave states had enough white voters to potentially swamp the small states. Virginia alone had as many eligible voters as Delaware, Rhode Island, Vermont, and New Hampshire combined. So the idea that, and overwhelmingly, the big slaveholding states were against the idea of the Electoral College. Okay. So, this quote, he says, the framers likely did not want their views to control constitutional interpretation. Nothing indicates that the original meaning of the Constitution was to create judicial review if it was, that it was meant to create originalist judicial review. In fact, the evidence, including the Ninth Amendment, points to the contrary. Okay, so the big thing to understand about what he's saying is okay, if nobody has the power to review the Constitution, then the words in the Constitution can mean anything you want them to mean. So if nobody has power of review, the Constitution has no meaning at all. So why would they go through this elaborate farce to draft a document and then send it to the states for ratification? And they were given the option of take it or leave it. The states had no option to amend or change the Constitution. They had to accept it as is. So if no one can review it, it has no meaning. If anybody can interpret it, and not a specific body or a specific person, then the words have no meaning whatsoever. So the whole point, there is no point to it. For instance, if we understand the constitutional process, the president doesn't have the power to declare war, despite being commander-in-chief of the military. Well, if those words can be reviewed by anybody, or can't be reviewed by anybody, depending on which way you want. If they're open to interpretation by all or closed to interpretation by all, then the words have no meaning. The president could do whatever he wants in terms of declaring a war. Now, one of the things that's important to understand when you talk about in the Constitutional Convention of Virginia, and this is when they're ratifying the U.S. Constitution, a larger argument did break out over the Judiciary Clause, and Madison said outright it could have been better expressed. And he lamented that they had to choose certain wording in order to get it through the initial drafting process in Philadelphia. So I got a little bit. This particular book here is probably the most thorough book on the ratification process at the state level. There's nothing else out there like it that I'm aware of. And I would call this pretty neutral, even though like I would disagree with some of her ultimate conclusions where she believes the Anti-Federalists actually won the outcome of the Constitution, where I would disagree with that. So, but ultimately, I would say most of it, what she's doing is reporting what actually happened. Okay. So these are letters between Jefferson and Madison, where Jefferson's arguing on behalf of a Bill of Rights, and Madison was pretty much against it until he feared for a second constitutional convention to occur. Okay. However, the federal constitution left some precious articles unnoticed and implications against others, so it needed a Bill of Rights by way of supplement. If rights could not be stated with the requisite latitude, half a loaf is better than no bread. If we cannot secure all our rights, let us secure what we can. A Bill of Rights would also help the states guard against federal abuses of power, and if experience showed the inefficacy of a Bill of Rights, it also showed they were rarely inefficacious and better than nothing. A brace, the more, will often keep up a building which would have fallen without that brace. Jefferson agreed that the tyranny of the legislatures, where majorities ruled, is the most formidable dread at present, and will be for long years, but not forever. That of the executive will come in its turn at a remote period, so the usefulness of a Bill of Rights against the government would increase with time. Also, he added, another item to Madison's list of ways in which a written Bill of Rights might be of use to the Republic. The legal check which it puts in the hands of the judiciary, an independent judiciary composed of men like George Wythe, John Blair, and Edmund Pendleton, would give a Bill of Rights teeth. He admitted that the Declarations of Rights might sometimes cramp governments with its useful exertions, but that was short-lived, moderate, and reparable, while the disadvantage of having none were permanent, afflicting, and irreparable. So the point they're making here is that they actually did have judiciary review in mind. How far up that goes, we'll try to get into a bit. Now, one of the things that's probably the most major item that explains where the idea of judicial review comes into play is the Marbury versus Madison decision. And this decision occurred within the lifetime of the most critical drafters of the Constitution, including Madison himself. Although there were some people, I believe Jefferson was one that was concerned about how this was implemented, there was very little in the way of outcry. If the Marbury versus Madison decision would have been considered completely out of bounds, totally not what the Constitution had in mind, Congress had the power to remove the judges of the Supreme Court if they so chose, and no movement in that direction ever occurred. So it's very likely, now it's always possible that there was kind of a change in mind from the ratification to the point Marbury versus Madison occurred, but it's equally likely that this was something they had in mind for it to happen as well. Now, the author referencing the Ninth Amendment, I honestly don't know what he's trying to say there. First, the Bill of Rights was not part of the original document, and the entirety of the Constitution was ratified without a Bill of Rights. The Bill of Rights was written by the first Congress, and their reasoning for writing a Bill of Rights down is there was rattling from the anti-federalist camp of setting up a convention of states in order to enforce a Bill of Rights. And Madison so feared this that he basically moved off the fence and decided that a Bill of Rights had to go in. So here's what Madison had to say on the Ninth Amendment. Quote, the exceptions here or elsewhere in the Constitution made in favor of a particular right shall not be construed as to diminish the just importance of the other rights retained by the people, or as to enlarge the powers delegated by the Constitution, but either as actual limitations of such powers or inserted merely for greater caution. So the Ninth Amendment refers entirely to the rights that are in the Constitution in saying that these are not special. They don't carry greater weight than the rights we don't talk about, nor is there an inference that these are the only rights that exist. So that these have anything to do with the judiciary review, I'm sorry, don't see it. All right, so he's talking in terms of, the author once again is talking in terms of judiciary review. Says, no such power existed in English courts. One would think if the framers meant for the Constitution to deviate from English law and practice in such a fundamental way, they would have been explicit about it. Essentially, judiciary review does exist in English law. I'll quote this little blurb on it. At the same time, the doctrine of parliamentary sovereignty does not allow for judicial review of primary legislation. This limits judicial review in English law to the decisions of officials and public bodies in secondary legislation, against which ordinary law remedies and special prerogative orders are available in certain circumstances. So, in the English system, under English law, judiciary review was allowed. And what is judiciary review? It basically is when a judge or panel of judges sits down and actually looks at the law to see if it's valid. The Parliament of England was supreme. The way our government is set up, At best, it can be considered co-equal. Uh, and the three primary branches, if you would follow Hamilton's lead, the judiciary is the weakest of the three, only because Congress has the power to determine how it's set up, as well as the ability to remove judges. Okay, so the author of the article acknowledges, quote, Alexander Hamilton argued for this power in Federalist Number 78, so perhaps it is assumed that judicial review would exist. Well, okay, I'll be the first to knock on Hamilton because Hamilton's idea of the government, he looked at the Constitution as merely a stepping stone to much greater power. Much later on, people would look to check him on his ideas of how powerful the central government should be. But one must assume at the time he's writing the Federalist Papers, which were essentially op-eds in the newspapers, that he was expressing things that were in the center of the belief system of the people who drafted the Constitution. This was an attempt to convince people to ratify the Constitution at the state level. So Alexander Hamilton, even if you don't believe he believed in what he was saying, you have to accept the idea that what he said was the will of the convention itself. And here's what Hamilton said on that in Federalist Number 78. By a limited constitution, I understand one which contains certain specified exceptions to the legislative authority, for such instances as it shall pass no bills of attainder, nor ex post facto laws, and the like. Limitations of this kind can be preserved in practice no other way through the medium in no other way than through the medium of the courts of justice, whose duty it must be to declare all acts contrary to the manifest tenor of the Constitution void. Without this, all reservations of particular rights or privileges would amount to nothing. So clearly Hamilton believed this was something that the Constitution was saying was there. Hamilton was by far wrote the most in favor of the Constitution under the general heading of the Federalist Papers. Okay, another item that the author says is some states did exercise that power, but it's a flimsy basis for such a consequential authority, which had been central to American constitutional law and government since its creation by Marbury versus Madison in 1803. Okay, there's a reason why the state governments look so much like the federal government, that they have a lot of things in common with each other. The state governments preceded the federal government. The federal government mimics and to a certain extent copies much of the layout of the state governments because this is what people were familiar with. This is what the legislatures of those states were familiar with. So the federal government is going to look like the state governments because it's the most likely thing to pass. If they created something incredibly different, people would say it's alien. But they would say, hey, it's the same thing we have at the state level, but just one higher level up. We know how ours functions. It's relatively easy to understand how a higher level would function. So that state governments were models for the federal government. So the idea that if the states had review powers, judicial review powers, that's a flimsy basis is poor reasoning. Okay, again from the author. A commitment to originalism, one might argue, requires abandoning judicial review altogether. It is incoherent to seek the original meaning for how courts should exercise power when the idea that the original meaning of the Constitution was ever to give them that power remains unsupported. Once again, if nobody can review the meaning of the Constitution against the law, the Constitution has no meaning. Okay, so obviously the people who wrote it intended it to be interpreted a specific way. Now, you could argue that they believe that as time went on, anyone could interpret it any way they wanted, but clearly they themselves believed in original intent, at least as long as they lived. Okay, from the author again. The delegates also took steps to shield the convention records from public view. They met under a rule of secrecy and preserved the records' confidentiality when they adjourned by depositing the documents with George Washington. The records remained in confidential limbo until 1818 when John Quincy Adams organized and published them. Okay, I think he's trying to infer that the goal was that the people of the convention were trying to not let what they said there influence how the Constitution was interpreted. And that's literally not the reason for the secrecy. Okay, first, the convention at Philadelphia was a conspiracy. Essentially, you had a series of meetings in various states where the future Federalists got together and decided, hey, we want to get rid of the Articles of Confederation. We want a new document. We want a new central government. We want a national government. This view was not something that the general public was having an outcry of. For the most part, people were generally happy with the setup. And that could be for lack of a better alternative, but nobody was crying out for something new. And the whole of these meetings would have come to absolute nothing if they hadn't convinced Washington to come along and say, hey, we need your weight behind us to make this happen. In fact, he was approached numerous times and refused, and only because of how he believed Shays' rebellion impacted things did Washington decide that some new system needed to come into place. So at the time this was happening, they were acting not only against the orders of their state governments, but they were also acting against the general will of the people. So the reason for the secrecy and the reason why all the notes were held is if this thing all went south and everyone said, wait a minute, what are you guys trying to do? Nobody wanted proof showing what it is they talked about. And of course, part of it also was to give people, if they knew that their notes weren't going to be circulating in the newspapers, it would allow for more open discussion where people were willing to throw out ideas that were more controversial, which could be beneficial to the general debate. But the idea is that they were, oh no, we don't want anyone understanding what we wrote, so that's why we're hiding our notes. Nonsense. The notes did not need to be released while a majority of the drafters lived because these guys were consulted. Madison himself was consulted on the meaning of some of the things in the Constitution. And another thing to understand, far more notes were destroyed and lost than were ever published. Several of the note takers, when at a certain position in their lives, had an option of either leaving these papers to heirs or publishing them, opted for destruction instead. We don't know the reason for them destroying it, but I doubt they were trying to protect people from originalist thought. Okay, so, and I'm going to close up here fairly quickly. Here's the author's, I guess this is his way of, his idea of a death blow. Those looking for evidence of original meaning in the Philadelphia debates often use Madison's notes. These are apparently the most comprehensive of several unofficial reports, yet they covered no more than 10% of the proceedings. Madison himself treated his notes as private property because he thought the proceedings could never be regarded as or an auricular guide in expounding the Constitution. So, give me a second here. Okay. So this is from Madison and Constitutional Interpretation by Donald O. Dewey. Unless constitutional interpreters kept constantly in mind the intentions of those who ratified the Constitution, he warned, he being Madison, there was great danger of innovations which would drastically change the government. Thus, it was the duty of all to support the Constitution in its true meaning, the meaning that was given by the nation at the time of its ratification. In constitutions, as in laws, the key to their true meaning was the knowledge of the original evils which they were intended to cure or the benefits they were intended to attain. He suggested several sources from which this information could be obtained. They were listed according to Madison's view of their importance. First, the state ratifying conventions. Second, the expositions of the Constitution in the newspapers of 1787 and 1788, which would be the Federalist Papers and the Anti-Federalist Papers. Also, the acts of early Congresses under the new system of government, and the views of the Federal Convention, which drafted the Constitution. Okay, so, I don't want to... Okay, so let's read out the entirety of the quote that the author was attempting to snip. Quote, whatever veneration might be entertained for the body of men who formed our Constitution, the sense of that body could never be regarded as an auricular guide in expounding the Constitution. As the instrument came from them, it was nothing more than a draft of a plan, nothing but a dead letter until life and validity were breathed into it by the voice of the people speaking through the several state conventions. If we were to look, therefore, for the meaning of the instrument beyond the face of the instrument, we must look for it not in the general convention which proposed, but in the state conventions which accepted and ratified the Constitution. So the gist of what's going on there is that Madison held the essentially the debates that occurred in the state conventions to be far more important than what came out of the National Convention, because the National Convention was a draft to a certain extent. But the thing to remember is that it was given to the states as a take it or leave it affair. So it's not like the individual state conventions had the ability to alter the document that came out of the convention. What I believe Madison is trying to say is, without the people's backing, it was nothing. That doesn't mean that the words had no meaning, nor that the people who wrote it didn't intend for people to look to them for understanding of how the document was meant to be interpreted. Okay, so yeah, I think that covers that. Makes me more inclined to cover a little bit more of the history of that period to help put it in context for everybody. But thank you for spending time with me this evening on this. If you're watching this and you have comments, feel free to comment. I do frequently reply to comments. If you liked it, like it. If you think there's somebody out there who could get use out of this, share it with them. And once again, I appreciate you spending time with me. Thank you, and I hope to see you again in a future video.